Good morning. My name is Jessie, and I'll be your conference operator today. At this time, I would like to welcome everyone to the Client Intake Best Practices conference call. All lines have been placed on mute to prevent any background noise. If you should need assistance during the call, please press star and then zero, and an operator will be back online to assist you. Thank you. Ms. Marsicano, you may begin your conference.
Thank you very much, and welcome, everyone. We're happy to be here, and we are excited to have three excellent speakers on the line. First, we have Dominic Lazara, who is a trial attorney with Lee & Lazara, PLLC in Tampa, Florida. He practices general civil litigation with a focus on personal injury. Dominic is extremely active in his community, devoting 25% of his practice to pro bono work and activities, and is the author of a legal blog chronicling the life of the young lawyer, which you can read at domlawfl.wordpress.com. And then we have Natasha Shizhoff. She's an attorney with Jaspin Schlesinger LLP, located in Garden City, New York. She concentrates her practice on all aspects of business and commercial litigation. She has represented both corporate and private clients and has handled a number of complex commercial cases, specializing in breach of contract, fraud, breach of fiduciary duty, dissolution actions, and shareholder disputes. She has extensive experience in all aspects of litigation, including pretrial issues, procedure, trial, and appellate advocacy. And most recently, Natasha was named to the 2015 and 2016 New York Metro Area Super Lawyers Rising Stars list and received the Maurice A. Dean School of Law at Hofstra University's 2016 Top Woman in Law Award. She's currently serving as the co-chair of the Business Law Committee of the American Bar Association Young Lawyers Division and is a liaison from the New York State Bar Association's Young Lawyers section to the Commercial and Federal Litigation section. Lastly, we have Kaufman. Ari received his BA from the University of California, Los Angeles, and received his law degree from the Southwestern Law School. Soon after becoming admitted to practice law in 2013, established the law offices of Ari Kaufman. Ari's practice business law and intellectual property, litigation, and counsel. Thank you all for being here, and I think what we're going to do is each speaker about 10 to 15 minutes to talk. If you have any questions, you can email me during the conference at lauren.a.marcicano@gmail.com, which is lauren.a.marcicano@gmail.com, and we will try to get those questions answered for you. So first up, we have Dominic. Thank you for being here.
Hey, thank you so much for having me. I'm happy to be here. So for everyone on the call, I'll briefly just go over, since every speaker has their own diversified background, I'll be focusing in more on the personal injury aspect, professional malpractice aspect of client intake, because that's the areas that I primarily practice in. And that starts really with finding clients. Obviously, to have clients, you need to find them first. I don't know how it is across the country, but I can tell you that in Tampa, the personal injury market and any kind of tort practice is incredibly competitive. So the best way that I've found to find clients or have clients find you is really through personal relationships, fostering those personal relationships as best as you can, relationships with business owners, relationships with doctors, chiropractors, relationships with other attorneys, business owners. These are all, you want to think about connectors, people that interact with other people on a daily basis that will be able to have the greatest exposure to the largest amount of people, because it's kind of like casting out a net. The bigger your net is, the more chances you're going to have of actually finding clients. So the next step is, after you actually get what I call is a PNC, which is a potential new client, you always want to, in terms of vetting, at least for me, because in personal injury and professional malpractice, you can get some interesting clients. So the way I always like to vet those calls is, or vet those clients, is beginning with a very brief 5 to 10 minute phone call, just to find out very basic information about them, about their claim, about their injuries, if they've received medical treatment, and if so, where. And if they pass that initial criteria, then the next step is you want to schedule an appointment with them as soon as possible. Kind of going back to the aspects of this practice area being extremely competitive, you have to be aggressive with actually meeting with the client. And I always like to meet with the clients. In that, if you'll find that some clients can't actually come into your office, so don't hesitate to schedule an appointment at their house either before or after business hours, and don't hesitate to go to their house to actually meet with them, to make that effort to go to them. Because if you allow, and I've told my partners and my associates this before, if you allow too much time to elapse between your initial touch with that client, your initial contact, and the time that you actually meet with them, you'll lose the client. It's just the way it works. I've seen it happen many times. So you want to get to that in-person interview as soon as possible. Now, actually, you want to show up to the interview with all of the documents ready, prepared. There's a chance that you may not sign them up during that first in-person interview. That's something that you're going to have to determine at the interview. But you want to have all of the documents with you. So if it's a personal injury claim, that's going to be state by state, but most likely your state bar is going to have a very standard form, which is a statement of client's rights and then a contingency fee agreement. And the contingency fee agreement works that you don't get paid as the attorney. You don't get paid unless the client gets paid. And I found that that's always the easiest way to explain it to clients. When they ask you, oh, how am I going to pay you? The easiest way on a contingency fee agreement is, look, I don't get paid unless you get paid. And then when I get paid, I will take anywhere from 33 to 40% of your recovery. Another cool way that I like to talk to more sophisticated personal injury clients is I'll tell them, look, you and I are going to become, after this fee agreement, we're going to become business partners, okay? And together, you and I are going to build a business. And that business is going to be, I'm going to work on your legal claim, and you're going to get healthy, and you're going to focus on you. And then once you get healthy and you reach MMI, which is maximum medical improvement, and we're ready to settle this case, when we settle that case, we're going to sell our business. And when we sell our business, the way it works is my percentage, my share of selling that business is going to be anywhere from 33 to 40%, depending on whether I file a lawsuit. And then your portion from that business is going to be the remainder minus investments that you had to make in that business. For example, seeing a doctor, requesting medical records, filing suit, filing fees, things of that sort. I found that that's a very effective way to explain a contingency fee arrangement. Like I said, to more sophisticated clients. For the less sophisticated clients, I just stick to the I only get paid if you get paid, and most of the time I don't actually have the clients pay costs if the outcome of the litigation is not in their favor. In terms of actually how to vet clients during the interview, one thing that you really want to look out for is, have they spoken to other attorneys, and how many other attorneys have they spoken to? Because, look, the reality is as a young lawyer and new to the practice, you're not going to get the really great cases, unless you're very lucky. You're not going to get the really, really great cases. You're not going to get the child struck by the drunk Coca-Cola driver. Those cases just aren't going to come your way. You're going to get the more difficult cases to try. And one good way to kind of sort out the good cases from the cases that you should never take is asking them how many other attorneys they have met with or interviewed with. It's a great way to vet clients, because if that potential new client has met with 5 or 6 other attorneys before coming to your office to meet with you, then you can look at that as, well, 5 to 6 other attorneys have met with this same client and decided not to take their case. So you have to take that into consideration about, well, what makes me think, why am I different? What am I going to be able to do different? Or what can I see that's different than those 5 or 6 prior attorneys that's going to allow me to actually have results or achieve results for this client? In terms of the actual client interview itself, for personal injury at least, you want to focus on damages. You want to focus on prior injuries, prior lawsuits. Are they litigious, meaning have they filed a lot of lawsuits in the past? Do they have a lot of prior injuries? These are all the ways that you vet a client. You have to be thinking, as trial lawyers, you have to be thinking as your client as a witness. So you really want to question your client, not to say aggressively, but as if you have to put yourself in the defense attorney's position. And you have to imagine that if this case goes all the way to trial, this potential new client is going to become my client, is going to be sitting on the stand, is going to be examined by the defense attorney. And that's applicable to depositions as well. So if you kind of put yourself in the shoes of the defense attorney during the interview, and be sure to ask a lot of questions, ask questions in different ways, ask the same question throughout the interview to see if the witness gives the same answer, because the reality is, especially when you're not taking those great cases in the beginning and you're taking some of those the weedy cases, the reality is that there's some clients that are not going to tell you the entire truth during the client interview. And it's crazy to think about a client that doesn't tell you the absolute truth, but it's going to happen. So that's why you have to almost take that defensive posture with the client during the interview to ensure that, hey, this is going to be a good client, this is going to be a good witness, this is going to be a good case. Especially for premise liability cases, you want to ask the potential new client, if you decide to take their case, you want to ask them to provide to you or preserve for you any physical evidence. So, for example, in a premise liability case, one thing that attorneys forget to do is ask them for the clothing that they were wearing on the day of the incident. Ask them for the shoes, the slippers that they were wearing. And if they have them, you take them from the client and you preserve them and you preserve the chain of custody, because those are going to be valuable pieces of evidence when the case eventually goes to trial, if it goes to trial. And another thing, think about it, you don't want the client continuing to wear the shoes that he was wearing the day he slipped and fell in Walmart, because he's going to continue to wear down those shoes, and they're not going to be in the same condition as they were when he was injured. In terms of other information or requests on during the intake process, you want to ask about prior medical treatment. You want to, when you can, have the client request the medical records, because oftentimes medical providers will not charge a client for medical records. However, they will charge you as the attorney, because they know that those record payments are eventually going to come from the client's case. So sometimes it's beneficial to ask the client to request the medical records. This is especially applicable if you do medical malpractice, because doctors and hospitals have been known to alter the records if the request comes from an attorney, versus the client requesting the records. There's less chance of the hospital or the doctor altering the records. Again, it's one of those things that goes back to clients sometimes don't tell the truth. I'll tell you, it happens. Doctors and hospitals, they alter records. It's just the way it is. So you have to prepare yourself as your client's attorney for that. In terms of conflict checks, that's really going to be entirely dependent upon the case management software that you use for your firm. One, from a personal injury aspect, one thing you have to be very careful of if you work in a mid to large size law firm, and your law firm does any kind of business or insurance litigation, you have to make sure that the person you may be suing is not represented by an attorney in your firm. For example, a Sedgwick. Sedgwick is a claims handler for a lot of premise liability cases. And you have to make sure that no other attorneys in your firm represent Sedgwick on the defense side, because then if you turn around and sue them, then that's a conflict. So in terms of researching claims, if it's a more notorious case, look for example, wrongful death, car accidents, things of that sort. See what you can find online. I can tell you from personal experience, I had a pretty bad auto accident case, and it resulted in the death of one of my clients, and I was able to go online. I was able to find a news article that explained what had happened during the crash, and it was through that news article that I determined probably not going to be a good case for me to take moving forward. In terms of resolving disputes before filing a claim, it really depends on the valuation of the case. You always want to start with a letter before filing a lawsuit, because you'll be surprised at the more cases you take and the more you practice, you'll be surprised what you can resolve with a letter versus filing a lawsuit. Sometimes filing a lawsuit is not really the best way to resolve a claim. The last thing I'll talk on about is pro bono work. I'll tell you that as a personal injury attorney, I don't necessarily get pro bono clients from the beginning. Rather, pro bono is something that I will decide during the client interview process. It's entirely okay. In fact, I encourage it if you meet with clients and who maybe they don't have the best personal injury case, maybe they don't have the best professional malpractice case. If it's something that you feel appeals to your sentiments and something that you can help them with, then it's entirely okay during that interview to decide to take the case on a pro bono basis, rather than just dismissing them from your office or referring them to another attorney. I've wound up taking some pretty cool cases against the city of Tampa because it's started with, well, they're here to sue their landlord for mold, and then it turns out to be an issue with the city, and I'll take that case in pro bono, and it's fun stuff, and I enjoy doing it. And at the end of the day, you're helping someone, and you might just get on the news for that. So lots of good can come from that. So you want to keep your ears open for those potential pro bono cases.
Perfect. Thank you so much, Dominic. I think that was a lot of really great information. For those that may have just joined, just as a reminder, this is Lauren Marsicano. Thank you for being here on behalf of the YLD Litigation Committee. I'm the co-chair and moderator of the event, and if you have any questions throughout, you can email me at lauren.a.marcicano@gmail.com. And next up is Natasha. Natasha, thank you so much for being here, and we're delighted to have you.
Thanks, Lauren. I'm happy to be here. I echo a lot of what Dominic has said, and my practice is predominantly, if not overwhelmingly, in commercial litigation. So a lot of my clients are business clients. Either they're coming in and they want me to represent the business that they're related to, or maybe they have a fight with one of their partners and they're looking to resolve it. Maybe they've already been sued. So there's a broad spectrum of what that client is coming in to see me about. So as an associate, I work for a larger firm in my area. I hope I can give you guys a different perspective of how I have to pre-screen clients, because a lot of times I'll be at work and I'll have a partner call me and they'll say, I got a call from a new client and they're coming in tomorrow and I want you to go and sit with them. So I don't get that opportunity to have a conversation with the client before they even come in to see me. I just have to get the information from the partner and then go from there. So once that client is actually in front of me, I really split it up into two portions of the interview. The first portion concentrates on the client, and the second portion concentrates on me as an attorney. With respect to the client, I really treat it a little bit like a deposition, which is what Dominic was touching upon, and I think that's important. First and foremost, the first thing I do, and it seems extremely elementary, but I can't tell you how many times in the beginning of my practice and career I've met with a client and then I get out and I realize, oh my God, I didn't get their email address or something as elementary as their home address to do a conflicts check. So the first and foremost, the first thing you do is very simple. Get the information. Find out who this client is, what company they're associated with if they're a business client, where they live, what the address is. Get all of that elementary information first and foremost. And in advance of doing your conflicts checks, one of the things you want to consider is what type of client is it? Is it an individual or is it an entity? If it's an individual, make sure you're not only getting their name, but do they have a maiden name? Do they have any other names that they go by so that way you can do a proper and full conflicts check? If it's an entity, it's important to understand the type of entity it is. If it's, for instance, an LLC or a small corporation, you want to get the names and the contact information for the members and the shareholders, because if you're representing an entity, you're obviously representing those individuals that make up the entity. So it's important to not only do a conflicts check on the entity, but the individuals that make up that entity. So once I get past all of that elementary stuff, I really just ask the client to tell me their story, and I just listen. And a lot of times you have a client that's coming in that's a business client, and unlike personal injury, for instance, with Dominic, there's a fight. They're fighting. They're either fighting with a partner, they're fighting because they're being sued because they allegedly breached a contract. They want to sue someone because someone allegedly maybe breached a contract that they're a part of, or breached a fiduciary duty, or committed fraud. So I really just, and it becomes emotional for the client, so I really just let that client tell me their story. And a lot of times they'll concentrate on things that they feel are the emotional elements of why they're in front of you. You know, I feel wronged, I feel that this person backstabbed me, or, you know, whatever the story may be. But for you as a lawyer, it's important to, yes, let them tell their story on the emotional end, but listen for the things that actually matter. Listen for the facts that are going to support the elements of whatever claim they want to either pursue or you have to defend. And in the same regard, probe for information. If they're there and they're saying that someone committed fraud or defrauded them in some sort of business transaction, well, you as the attorney, certainly as a senior associate or a partner, should know the elements of that claim right off the bat, and you should be listening for facts that are going to support either the claims that the client wants to pursue or the claims that you're going to have to ultimately defend. One of the things that I can't stress enough during the process of the client telling the story is watch out for emergencies. So with me, a client comes in and they are either plaintiffs and they're going to want to commence an action, or they're defendants and an action has already been commenced. From the plaintiff's end, and unfortunately I almost learned this the hard way, but I was able to deal with the emergency. You have to think about the statute of limitations. If a client is in front of you, or a prospective client is in front of you, and they want to sue somebody, they may have already waited X amount of years, days, whatever the statute of limitations is for the claim that you know they're going to have to pursue. And if that statute of limitations is up, let's say, in a week, guess what? You're going to have to do a lot more work right off the bat. And that'll affect what kind of retainer you're going to want to take, the amount of work that they're going to have to pay for initially. Plus, you don't want to meet with a client and miss the fact that, oh, by the way, they're telling me this story, and this story happened 2 years and 360 days ago, and I didn't commence an action within the next 5 days for whatever claim, and now I blew the statute of limitations. That's very important. Now, on the defense side of it, If the action has already been commenced and a client, a prospective client, is a defendant, you want to make sure, find out what's going on in that case, what's going on in the case procedurally. Has there been a decision and they may have had prior counsel and they want a new attorney? Well, if there's been a decision, the time to run with respect to appeals, motions to re-argue, or even complying with a particular court order may be coming up, and you don't want to come into the case as an attorney and take on that case representing a defendant without realizing, oh, by the way, I have to perfect an appeal in the next week. Again, that goes to not only making sure that your client is complying with everything that the law and the courts are requiring of him or her, but you also want to make sure that you're getting paid, whether it's through a retainer or just being realistic about how much work there's going to need to be done right off the bat. And the last part of the emergency category is just emergency situations. You might have a situation where your client is being deprived certain rights that he's entitled to as a shareholder or a member of an LLC, and you might have to go to court immediately on an emergency basis, and that too requires obviously a lot more work right off the bat. So once I let the client tell their side of the story and just get all the information that I can possibly get and assess what needs to be done, the second part of that interview is what I like to refer to as I concentrate on myself. First and foremost, obviously, if you have an emergency situation, you have to let the client know this is what needs to be done immediately. But if you don't, and most of the times you don't have that emergency situation, if you don't, the one thing that I would stress over and over again as a new attorney is be realistic. Be realistic with your client about what they're about to get themselves into, whether they're a plaintiff or a defendant. I have seen so many times attorneys, they really just want to get the client. They want to build their book. They want to get their client. And I don't want to say they promise, the moon, but you need to be realistic about, one, how much it's going to cost, because in commercial litigation, you generally don't have contingencies. It's usually an hourly fee and an hourly based fee arrangement. So you have to be very realistic about the amount of money that client is about to spend, and you have to be realistic on time. You can't say, well, you have a great case, and I imagine we're going to commence this action, and they're just going to call us and they're going to want to settle. That doesn't always happen. So, and litigation, depending on what state you're in, I'm sure it takes a long time no matter where you are jurisdictionally. It takes a really, really, really long time. It may take years. So before that client jumps in and says, I want to go sue someone, not only do you have to explain to them, okay, your claim, let's say, has a potential benefit of $100,000, but you may end up spending $100,000. And that's very important because especially for these business clients, I find that they are a little bit less emotional than other areas of law like family law or personal injury because they look at a litigation just like any other business decision. So it's a cost-benefit analysis for them. But absolutely be realistic because you're entering into a relationship with this client and you don't want to overpromise something and then underdeliver. You want to create a basis right off the bat. And not to mention the rules, the ethical obligations, certainly in New York, they require you to, they actually prevent you from taking on a case that you are not competent enough to handle. And competency is not necessarily an area of law that you may not have had experience in that you're not taking. Competency also includes, is your firm, or whether it's a solo, whether it's a big firm, is it capable of handling the type of case that's coming in? Is it going to be a financial burden? Do you have the staff resources to handle it? And if you have a client that's coming to you who's, part of a very, very big company and the claims that they're explaining to you are there's going to be extensive discovery, there's going to be extensive depositions, it's going to require a lot of manpower, and you're at a solo firm, you might consider referring that case to someone at a bigger firm. So it's important to think about that when that client's in front of you. Are you going to be able to handle it? through your own expertise as well as through what resources you have. So the other part to consider and make sure you're relaying is whether you believe that there's an actual claim here, whether it's a claim to be commenced as a plaintiff or defending, because you as the attorney, again, I'm pretty sure there's a national ethical rule, but certainly in New York, you have an ethical obligation not to take frivolous positions, not to bring frivolous claims. So you might have a client in front of you who's really just hot-headed, and they may say, well, this person did something to me, and I just want to sue them because I want to give them a hard time. You obviously can't do that, and I can't tell you, it doesn't matter how big the client is, how much other attorneys might take on that client. It's your professional responsibility, and it's more importantly your professional reputation, because you're the one that's going to be going on in front of these judges in the courts with opposing counsel in your community. And if you have taken a claim that you know is frivolous, not only can you get in trouble, but more importantly, you're going to jeopardize your reputation. As a young lawyer, as any lawyer, but more so as a young lawyer starting out, I don't think there's any client that's worth it, no matter how much you want to build your book. And with respect to going back to being realistic with time and money, I would also encourage attorneys to talk to the client about alternative dispute resolution and say, look, this is going to cost you X amount of money, or, to defend, to prosecute. Let's try to negotiate this. Let's go to mediation. Mediation is also costly, but it's certainly less expensive than full-blown litigation. Let's go to binding arbitration. These are things that you want to explain to your prospective clients so they can make an educated cost-benefit decision as to whether they want to go down this litigation route. So once that meeting is over, I think you need to be clear also and tell them that, one, there has not been an attorney-client relationship that has been created. They need to let you know whether they want to retain you, and you need to let them know if you want to take this case, and that includes doing a conflicts check. And if you have received information during your client intake that you believe you need to do some further research on to determine whether you have a valid claim, you can say, be honest. That's another thing. Definitely be honest. If you don't know something, if you want to double check with maybe a senior partner, that's okay. Tell them, look, I need to do a conflicts check. I need to vet your claims, and let's follow up either tomorrow or whatever, a week, whatever works for your schedule. And I find that clients, when you're honest with clients with respect to, again, time, money, what you know, what you don't know, they tend to be receptive to that. They don't want an attorney to just try to sell their business. They want an attorney who's going to be able to represent them the best that they can. So once that client is done, that the meeting is done, you want to go forward with the conflicts check. And the conflicts check, when, again, I'm at a bigger firm, I really don't have that much control over. What I do have control over is what I started speaking about, is the information. I have to take all that elementary information that I got and give that to our conflicts department, and they're going to be able to run a search. That includes, again, identity of members, shareholders, individuals, maiden names, whatever it may be. One other thing you could do individually once you're done with the meeting with the client is you could just search on dockets, just search on federal and state dockets to see if that person's ever been involved in a litigation before and what type of litigation. If you see that this client you just met with has had 5 malpractice suits against other attorneys, you may want to tell your partner or reconsider whether you want to take on that client. So once you get past that, and assuming you have a valid claim, assuming that you've done a conflicts check and everything checks out, and there's really one of two things that can happen: the client wants to retain you, or they don't want to retain you. If they do want to retain you, you have to provide them with an engagement letter. And I don't know if this is across the board in every state. Some states may make that mandatory, some states don't. You have to provide them with a retainer letter as well as essentially an outline of what the client's rights are. And the retainer letter is not only there to protect the client, it's also there to protect you, because a simple litigation matter can become quite complicated if a party, let's say, files for bankruptcy, takes an appeal, dies, and you're dealing with now an estate or a guardianship proceeding if someone becomes incapacitated. You want to make sure that your retainer agreement and your prospective client understands the scope of your firm's representation, because the retainer agreement should memorialize exactly what it is you're being retained for. If it's a particular litigation, identify the litigation by caption, by index number. If you want to exclude appeals, which is very common, make sure it says if something happens and you lose or win or you have to defend an appeal, that's going to require a separate retainer. So definitely the scope, definitely the charge, you want to make that abundantly clear. You also want to look at your state's individual rules. For instance, in New York, there is a mandatory arbitration provision that needs to be in retainer agreements, and attorneys are mandated to go to arbitration over fee disputes if it's under $50,000. If there's a fee dispute that deals the amount of money that's dealt with is under $50,000. So you want to present that, and you want that agreement because just like any other contract, you want it to be clear. And if the client signs it, great, let's move forward. And as far as your fee arrangement, again, with being at a firm that's a little bigger, I have less control over the type of fee arrangement we could offer clients. And certainly in my area of expertise, it's predominantly hourly. It's going to be a very, very rare case that you have a contingency fee arrangement in a business-related litigation. The retainer is something I probably have a little bit more control of, because as I'm the one that's in the interview, I can now go back to the partner that brought in this client and say, look, they have an order to show cause that I have to prepare immediately. There's a statute of limitations problem, or there's an appeal that needs to be perfected or defended immediately. That's going to take X amount of work. Or there's a particular motion that I think this type of client needs to be making immediately. That's going to take X amount of work right off the bat. You might want to take a higher retainer than something that's a little bit more standard or more routine that you know is not going to take a lot of time. The last thing, and this is probably the most important thing I'll say, is if the client doesn't retain you. If the client calls you, or even if the client just disappears on you and they never retain you, I cannot stress the importance of sending non-engagement letters, because the law presumes that an attorney-client relationship exists when the client essentially believes there's an attorney-client relationship, and you don't want there to be any ambiguity about whether an attorney-client relationship has been established. So if you have a meeting with a prospective client that doesn't end up in a retention of your services, you want to send them a non-engagement letter saying, thank you for meeting with me. We were not able to consummate a attorney-client relationship, and I wish you all the best. If you need anything else, please call me. But not only are you maintaining a relationship for maybe that client coming back to you in the future, but you're also making it very, very clear that you are not retained as an attorney. So if down the line something happens and 3 years from now that client commences an action and says, well, you told me to do X and I did that, you have this non-engagement letter saying I wasn't representing you, and that can really protect you as an attorney. And I recommend sending that non-engagement letter with either some sort of certified return receipt requested, or as an email with a read receipt, so you have proof for yourself that client received it. But other than that, I think that's everything I have to say. And just as I guess the last thing on the non-engagement letter, if your client does retain you and you go through that process and you ultimately litigate the case, it's important to also send a closing file letter once that case is resolved for the same reasons as you would the non-engagement letter. It ends the attorney-client relationship, so if there are any issues going forward, you have a clear date of when that relationship was terminated.
Excellent, Natasha. Yeah, and I think we all couldn't agree more. The couple things you touched on, which could lead to malpractice, with the statute of limitations and the obligation for competency, as well as these non-engagement letters, are invaluable for attorneys to recognize to avoid litigation and malpractice suits, and bar complaints. So thank you so much for that perspective from the commercial litigation bigger firm. And last but not least, Ari, we're excited to hear from the intellectual property perspective of a small business owner, a solo practitioner, I believe.
That is correct. Thank you so much, Laura. And I just want to start by thanking the Young Lawyers Division and especially the Litigation Committee for giving me this opportunity today to share my experiences with everybody. My experiences do overlap greatly, substantially with my co-panelists. But first of all, I wanted to say that I've been in practice for 3 years, so that's a little bit different than the other members of the panel today. The steps I take are also a little different. I started my practice mainly by word of mouth, and I still retain most of those clients today. But I started supplementing my practice about a year and a half ago with some SEO. I have a website now, so I've been getting a lot of inquiries through there. It's probably about 30 to 35% of my practice at this point. And when I get an inquiry, it's usually in the form of an email. And as soon as I get the email, I will return the email immediately because a lot of clients will be sending multiple emails. They're not just sending it to you; they're sending it to many lawyers at the same time to see who's going to bite, so to speak. So I immediately return the email, and then I try and set up a meet. That's not always possible because a lot of clients will live in other states. I'm here in California, and California is a very litigious state. So a lot of people will get sued in California, and then I'll have out-of-staters that will get in touch with me through my website. So the first thing I do is I try and set up a meet. If that's not possible to do in person, I'll set it up via one of these new, devices that you can set it up with, either FaceTime or there's something on Samsung. I forget exactly what it is, but you could also do Skype. There's a lot of these webcam type things that you could use to meet your client in person so you know who you're talking to. I think that's extremely important. If you don't know what the person looks like, if you don't know the way their facial expressions are when they're talking to you, how do you really know whether they're telling you the truth at all or whether you're being sold a story? To that extent, I just want to reiterate a few things that my co-panelists were saying, which is if a client comes to you and they're saying that you have to do something really quickly, they're in an emergency situation, a red flag should be going off in your head immediately. Has this client talked to other lawyers who have turned them down? Has this client waited an extremely long amount of time to, bring their claims to the court or bring their claims to an attorney's attention? So there's a lot of things that you have to bear in mind, and ethics rules come into play greatly there as well. You can't just turn down a client like Natasha was saying. You can't just turn down a client without sending them, a termination, a non-engagement letter, something along those lines, to know that you're protected and they're protected to some extent as well. They don't think to themselves, this guy's handling it, I don't have to worry about it. So there's always those ethical rules to keep in mind, and there's a lot of them in California. So if you're a California attorney, you have to read through them in great length. You should always have some kind, when you're in front of a new client, a potential new client, you should have something written down that you should always ask. I try and always ask, for the clients to come and after meeting me, I also ask them to do something for me. For instance, I'll ask them to send me an email with what we discussed, what the main points that they wanted to discuss with me today, whatever the day were. And if they can't do a simple email, then, what are you going to do when you're trying to communicate with the client during the case? So, and that brings me to how my practice is set up. So I don't do any contingency fee cases, so that's a little bit different than Dominic. It's not something that I could do as a solo practitioner at this point, and I don't take any personal injury cases either. I focus more on business-related matters such as trademarks, patents, copyrights, things of that nature. A lot of breach of contract cases, and litigation. It's mostly litigation. So when you're doing litigation, you have to make sure that of three things. The first thing you have to make sure is that, above all, as a solo practitioner, I have to make sure that the client can pay. That's just the reality of my situation. So you have to make sure that the client also knows that litigation is extremely expensive. So once you found out that they can afford litigation and that they know how expensive it's going to be, then you have to find out if they have the stomach for it, so to speak. It's brutal out there, for some people, and opposing counsel can really tear a client apart. So you have to find out if they have the stomach for it, and that comes into play quite often. If they're squeamish at all, I mean, like Dominic said, they're going to be a witness at some point if it goes to trial. And as a litigator, you have to always assume that your cases are going to go to trial. And you should do everything from client intake until you send the closing letter for the file. You should assume that it's all going to trial. It's all going that way. And most of my cases actually settle. I would say 90% of the cases that I do settle before I have to even do very much at all. So there's that to consider, but at the same time, you have to realize that some of them do go to trial, and you're going to have to call your client as a witness. It's always going to happen. I've had a couple of cases that came to me from good clients, people that companies that I've represented for 2 years, 3 years, and they asked me to do things that I would consider, they're just not something that you can really do. They got damaged, screwed over to some extent, and they want to be compensated. They want either their money back or whatever the situation is. And you're going to be in a position as a solo to have to tell the client that, that's not something that I'm willing to take on. I can refer you potentially to other attorneys that I know, but that's not something that I can personally take on. So there's all those things to consider when you're pre-screening a client. That's like the first interview and the second interview. So if they can't send me an email stating what it is they want me to do, then there's no way for me to be able to prosecute the case or to defend the case, whatever the situation is. If you can't communicate with your client, everything breaks down. I think every single attorney substitution that I've seen, and as a solo, I get a lot of clients that have come to me and their cases are already being, litigated, and they have to either fire their previous attorney, or sometimes, as I found out, their previous attorneys fired them. So every single substitution of attorney that I've seen, or 99% of them, it was all because of a breakdown in the client attorney, the attorney-client relationship, right? So that's something that you have to worry about from the get-go. Is this client going to not be able to stand up on the stand and give their story? If they can't even tell their story to you in an email or anything like that, then you just have to refer them out or send them the non-engagement letter. But you can't just take a case to take a case. There's no. If you do that, you're going to end up taking cases that are going to take you years to get through. You're not going to get paid well. It's not a good idea. So that's one warning that I would give right up front. If there's red flags, pay attention to them. Then on fee arrangements. So like I said, I don't do contingency fee, and I do different fee. I do like a staggering fee, so to speak. When a client comes to me and it's pre-litigation, for instance, I'm not going to charge them my litigation hourly, because that's when I really have to dig deep, do a lot of research, do a lot of writing. That really requires all of my concentration. That's not something I could do, 15 minutes here, 15 minutes there. So, for instance, I have probably half a dozen matters right now that are pre-litigation, and I'm doing settlement negotiations with the opposing counsel. Sometimes the client came to me when a case had already been filed, or as in a few of the cases I have now, they came to me, after the case was filed, and so if the client comes to you before the case is filed, then you're just negotiating with an opposing counsel that's threatening to sue. If they come to you after the case is filed, your client's already in the hot seat. So if you're doing negotiation, when I do negotiations, I should say, in my experience, I will give a break in the price, and I'll only do an engagement letter. I won't do a retainer, because for me, when I'm just sending emails, even if I have to do a little research to write the email and respond to opposing counsel's email, that's not the same to me as sitting down and I'm going to do research now for the next 6 hours, or I'm going to write this motion, and I'm going to be in it for the next 4 hours. I can't do anything else. So that's why for those type of things I require a higher hourly rate. and like I said, everything is hourly. So if the client isn't prepared to pay hourly, for me, in my practice, I send them to many good attorneys I know that take contingency fee cases, and some of them have had a lot of success, and some of them have even, told the client at the end that they were going to give me a percentage, and money came back to me that way. So that's something to consider. And a lot of people that focus, like I do, on only certain kinds of cases, you're going to get other cases. What are you going to do with them? You're going to turn them down and just let the client go somewhere else if it's a good case that you don't want to take it? No, you're going to refer it out, and you're going to hope for the best for the client and the best for the attorney you refer it to. And if you get something back, that's also great. But like I said, so for litigation, I charge a higher hourly rate. For negotiations, and if I'm just emailing and things like that, I charge a much lower hourly rate. Vetting your prospect to understand their financial viability, I mean, in reality, there's really no way to do that. I mean, how are you going to know? You're going to judge by their shoes or by their belt, by the watch they walk in with? I mean, plenty of people, especially I live in L.A. specifically, a lot of people in Los Angeles will drive the nicest cars and have the nicest watches, but when it comes to paying your bill, somehow the money's all gone. And by the way, just so that the people that are going to be solos know, if you're doing hourly rates, every single client, in my experience, will ask for a discount. It's just they're always going to ask for a discount. So I definitely think it's important to make sure that you write down and you have a good timekeeping program so that you can keep track of every single hour. Bill them for every hour, because they're gonna, even if you don't think, you're like, I had a phone call with the client for 15 minutes. I'm gonna bill him for 50. You're gonna bill him for 50 minutes because he's gonna ask for 30-40% off the bill. So if you don't bill him for everything, then you're really losing out. So there's that to consider. And a lot of times you become friends with your client, so to speak. Although you have to keep it, it's a business relationship still. But especially if you're getting clients from your community, it's your community. You might know this guy. You might see him in your I'm Jewish in my temple, or if you're Christian in your church, you're Muslim in your mosque. You might see them around. You're going to be friends with this guy. So it's possible that it will come to that kind of relationship. But you have to be careful when it comes to certain things. Even then, what's next? Best practices for conflicts check. I don't really have such an issue. Two times in my career, I had an issue where somebody had wanted to sue somebody that I already represented. So in those cases, I referred them out. As soon as they told me who they wanted to sue, I knew it was a client, and I just sent them on. So there wasn't really much to check. It was more like, okay, conflict, and then goodbye. You have to really be careful about clients coming to you, and I think Dominic said this, and lying, so to speak. Like, clients they'll come to you and they'll sell you the world. I'll give you 40%, all this, all that, whatever. They'll do anything to sell you sometimes on taking their case, because they're either desperate or they see you as a solo and you're not going to charge them a lot, and then they could even get a bigger break on the deal on the invoice or whatever later. So you really have to be careful of those kinds of things. You always want to research a client. I Google every single one of my clients. I Google the owners, the service of process on the Secretary of State's website. I Google everybody and everything that I possibly can to know who I'm going to be dealing with potentially for the next, I'd say, at least 2 years, pretty much. And then you're responsible from an ethical perspective to be responsive to that client, especially if they ask for their client file or something like that. For here in California, it's 5 years, so it's quite a bit of time that they could come back and say, hey, what's the deal? Give me my file. So you can't just write them off as soon as you're done with the case, or you settle the case, or whatever the resolution was. Obviously, the main thing I have to do as a solo is what I call manage client expectations. Clients will not only will they sell you, but they'll try and get the world. They'll try and say that this guy did 100 million things that he never did. So, that goes back to what I was saying before, where you want to make sure that your client is telling you the truth and vet them as highly as possible from Google. And I have a software program called CourtLink. It's with LexisNexis. And with CourtLink, I could literally find out every single litigant, if they ever were involved in any kind of litigation. It draws it up from every single state, every single every single federal court. It's really handy for a solo to have that tool at their disposal. So I vet all the clients way before I send them an engagement letter. If I feel there's any red flag, I will refer, or just, I've actually never sent a non-engagement letter, but I think that's a really, really good practice, and I'm going to implement that as soon as possible. There's the main thing I want to get across is solo practice is very different. If you get in bed, so to speak, with somebody who just wants too much or is unreasonable, you could end up spending huge amounts of time devoted to a case that is not going to win, and you have to worry about your career, you have to worry about your standing in the community, perhaps. You have to take a lot of things into consideration. It's not just what's sitting in front of you, it's also what comes later. So think about the consequences, think about the ethics rules, keep all of that in mind even as early as the client intake. The client intake is actually probably one of the most important parts of a attorney-client relationship. So if you keep all these things in mind, I think everybody will be much better off.
Thank you, Ari. I think those are some really great points from a solo perspective. And we actually have two questions that I think we might be able to hit really quickly before the time runs out. The first one is for you, Natasha. Should we be careful in filing a complaint and be ready to amend after you've completed deeper investigation of the claims and warn the client of the possibility of missing claims because of such short statute of limitation notice?
Absolutely. I mean, you should always be on the lookout to potentially amend your complaint depending on what comes out of discovery. It may not even be something that, the information the client's relaying to you. Yeah, you might have to do something quickly, and you may not be able to be comprehensive with the facts right away, not because your client doesn't have the facts, but because you don't have the facts from opposing counsel. But if the question is, what if I miss something factually because I'm not getting it from my client? Sure, that may happen because your client's withholding information, but it shouldn't happen simply because it's an emergency. You should be able to get the facts from your client regardless whether you have to file a complaint tomorrow or in a month. If it just so happens that you may have forgotten a potential claim, you could, of course, amend your complaint, and I encourage practitioners to do that. And I know in New York you could amend it as of right within a certain amount of time after filing the complaint and before an answer has been filed. And if it's past that time, you'd have to make a motion for leave to amend, which is generally the leave is pretty widely given, especially when there's no prejudice. So absolutely, definitely amend your complaint if you feel that you missed a claim or you have an additional claim because you either forgot it, and we're human, that happens. Your client may have withheld information from you. That happens too all the time. Or a claim just comes up because of discovery you got from opposing counsel. I definitely think that it's a work in progress. It happens, but I think it happens a lot more than people think it does, where what you file initially is not what you're going to end up with at the end of the day when you go to trial.
Thank you, Natasha. And Ari, I think this one's directed toward you.